Excited about today's topic again. My name is Corey Parnell. I'm a principal at BGM. I'm excited about the panel again that we have today. This is part two of a two-part series on estate planning. And what I really like about this is we really have three key players here for the conversation. We have Rachel on the law side, the attorney, Michael on the tax side, and then also Leonetta on the trust and estate side. And just very quickly, Rachel Dahl, she's with a law firm, DeWitt, located in Minneapolis, and she's a seasoned estate attorney who advises individuals, family, and business owners on matters ranging from wills and trust to charitable giving and then succession planning. Then we have Leonetta Rence, who's with Cornerstone Trust Company, and she has extensive experience in the trust administration and estate planning. She really specializes working with high net worth individuals and families through very complex wealth transfer strategies. And lastly, my partner, Michael Andrews, who's a principal at BGM. He specializes in estate and trust planning for high net worth individuals and families as well, offering strategic guidance on wealth transfer, tax efficiency, and legacy preservation. So with that, I want to turn it over to Michael. I think he was going to just touch base on the current legislation that's kind of being kicked around right now at the federal level.
Yeah, thank you. Thank you, Corey. So I know since our last meeting, a lot has kind of occurred, which you may all be aware, but either way, it really makes it imperative that regardless of what happens, that good planning is something that you should continue to think about and do if you haven't already. And as you probably know, the big beautiful bill it passed the House and is currently sitting with the Senate, and they have a self-imposed deadline to have the legislation complete by July 4th. So we should be hearing some things soon. And part of this bill would make the lifetime estate gift and GST tax exemption to $15 million. So currently it stands at $13,990,000. And the change will become permanent, but that's a loose word. So it would be permanent unless it's later amended or repealed. And as a follow-up to our last meeting, we're going to dive into additional details on planning and why it's important, even if the big beautiful bill does pass. And we're going to hone in on the Spousal Limited Access Trust. Some of you may have heard the abbreviated term a SLAT, but there are many other planning techniques which may be incorporated into your estate planning, and we'll touch on some of those as well. So with that, I will pass the torch to Rachel, who will kick us off.
All right, thank you, Michael. So, and thanks to our viewers. We know some of you are repeat attenders, and some of you are joining us for the first time. Our previous session, we discussed the current law, the fact that unless something is passed this year that would extend the current law or replace it, such as the big beautiful bill, we are looking at this $13.99 million per person exemption sunset to an amount ranging from, we think, $6.5 million to $8 million per person, which is a big reduction. We talked a little bit about revocable living trusts and how those trusts can be structured to help make your estate more tax efficient. And we touched on a little bit about the urgency here and what would need to happen and why the urgency is what it is. So come July 4th, if we have nothing in place that would extend the current legislation or replace it, then we're looking at December 31st this year being the last date that this exemption would be in effect. And so we want to remind everyone what this looks like logistically, because before we talk about the mechanics behind the SLAT or any irrevocable trust, And that's really going to be our focus for today. The irrevocable trusts and how those can be used to make you more tax efficient. But Leonetta, from your perspective, you've mentioned what you find in terms of timelines and what it looks like when the rubber hits the road. And what do you see as a drop dead, or what's the timeline that we're working with here?
So one of the things that we've determined is that if you're transferring assets, whether they're marketable securities, real estate, closely held assets, we need to start transferring those assets drop dead by November 15th. So when we're talking about November 15th, it's really easy to get market values on marketable securities. But if we're transferring any other asset, any other type of asset into these trusts, we need appraisals on real estate. If you decide that you're going to put a life insurance policy in there, we need an enforced ledger to, figure out the value of the life insurance. If there are privately held assets, businesses, we're going to need appraisals in order to determine what's the value of the assets that you are transferring into the account. The other component is we can't assume that the attorney that you're working with, whether it be Rachel, somebody in her firm, or somebody else that you've worked with in the past, is going to be able to get all of those documents completed for you so that you can start the funding process. So from a document standpoint, you really need to have everything, I would say, Rachel, by the 15th of October, so that you have the opportunity to review the document with your attorney, understand what you've actually put into the document, and get that document executed by the end of October so that we can start the funding process and get the account set up. If you're using an independent third-party trustee, it's going to take time to get that information set up on the system, collect all of the BSA AML documentation that a third-party trustee is going to require. And so you need to give yourself a little bit of time.
Yeah,
I
just want to jump in just real quick. I'm sorry, Rachel, is just to remind the people that are listening, this is an interactive webinar. So if you do have questions, please post them in the Q&A, and in the panel, as a question comes up, they'll address it. So I apologize about interrupting you, Rachel, but I do want our audience, to participate if you have questions. Rachel.
Perfect. Thank you. Right. And so if to our viewers, some of whom might be professionals who are looking to assist their clients with this process during this, this year and beyond, and some might be clients who are thinking about their own individual situation and whether or not these techniques might work. So if what we're talking about either last time or today sounds like something that you would benefit from or that you'd like to learn more about, now is really the time. And to Leonetta's point, now is really the time to get in and start asking the questions to determine logistically if these strategies would work for you, because there really are additional steps that go beyond just a stack of documents that you sign to put this together and make it work. And the types of trusts we're talking about today, we'll start off here, and I'll mention one that has become incredibly popular. Michael mentioned it. It's what we call a Spousal Lifetime Access Trust, or Spousal, or SLAT for short. And it is an irrevocable trust. It is designed to help married couples that want to take advantage of the current high exemption limit without losing access to their assets. One of the scariest, I think, ideas about putting together an irrevocable trust for someone is the idea that they no longer will have control over their assets and may no longer be able to benefit from those assets. Okay, and so with the SLAT, one of the pros is that basically how this trust is designed to work is that one spouse, and this would be the donor spouse, that's the spouse who's making the gift, would make a gift to the trust. And that gift, it can be cash, it could be life insurance, marketable securities, real estate, a business. It could be any of those types of assets. But the key is they're making a gift of that asset to a trust, which is set up for the benefit of the donee spouse. Okay, the donee spouse is the spouse receiving the benefit of the asset. Now, logistically, let's say that you own assets in joint tenancy, or if you are a resident of a community property state. So our neighbors to the east, Wisconsin, for example, is a community property state. You first would need to look at decoupling those assets from an ownership perspective before you can really use them or gift them to the SLAT. Now, again, you are giving away the assets. So your spouse really isn't the owner of the asset. It becomes an asset of the trust. Your spouse is the beneficiary, okay, of those assets. And you really are, as the donor spouse, you're giving up control. The saving grace with this type of irrevocable trust is that the beneficiary spouse receives distributions, gets access to the funds, and let's hope decides to share with you, okay? And so this becomes a popular type of trust for married couples. And keep in mind, though, one of the cons here is that it is a gift. And Michael will have you jump in here and talk about, once you gift the assets to the SLAT, is there a reporting requirement for that gift?
Yes, there is. So there will be a reporting requirement for the gift. And from our last meeting, we really touched on, kind of highlighted what the current exemption is and how those gifts will affect your current estate tax exemption and future estate tax exemption if there's no extension of the law or law change to either keep the exemption the same, index for inflation, or if not, it reverts back. So we're going to kind of dive into one. I'm going to show you a spreadsheet. If you're on our prior webinar, then I hope it looks very familiar to you. And for those who are not, I'll explain it anyway. And then we'll kind of dive into some examples in the event the current estate tax exemption is not continuing or it sunsets at the end of this year, how that affects your exemption if you do decide to gift, if you don't decide to gift, and how much you decide to gift. So I'm going to share my screen, and that way everyone can see what I'm seeing. Everyone see that? At least on the call.
Yes.
So last time, and I took out a top box that was called the SUI. And I do want to briefly discuss that for those of you who may have not been on the prior call. But the SUI is called the deceased spouse unused exemption. And all that means is that if you do have a spouse that predeceased, then their unused exemption can be ported over to the surviving spouse. And really some key takeaways for the professionals as well as individuals on the call. If you do have that DSUI amount, it is important that you do file an estate tax return. So in order for a DSUI election to be valid, you must file a federal 706 form and elect to transfer that to the surviving spouse. So it's not automatic. You don't just get it. You've got to file a return and actually show the amount going to the surviving spouse for DeSuya purposes. And also, if you happen to know someone, or if you yourself, if your spouse passed away, there are some revenue rulings that provide 5-year relief in the event you know, if you're under certain thresholds, you can get that relief. But if not, then you're not able to do that. So there is relief for certain estates. So just keep that in mind. If you feel like you know, we should have filed an estate tax return and it's been 9 months after death, and you're like, man, I wish I would have thought about that. Well, even if that's the case, under certain circumstances, you can have relief and still file an estate tax return to get that unused exemption ported over to the surviving spouse. But for this conversation, we're going to treat this as just, this is a single individual, and this is how their current exclusion is made up of. So if you think about it, we've got, prior to the Tax Cuts and Jobs Act, we had this certain exclusion. So currently that's 6,995,000. And then you've got this additional increase because of the Tax Cuts and Jobs Act, which is also the 6,995,000. So those together equal the current exclusion amount of 13,990,000. So when you're thinking about gifting, if you look at these key things to the left, it says 2025 gifts use this portion of the exclusion first. So you're using that old exclusion first. So if the TCJA amount gets removed because of, you know, the sunset of the law, then that's what you're stuck with. So, and we're going to kind of dive into examples to really hone this in, and we'll talk about one other thing based off of, you know, depending on what you give. So I've made 4 scenarios that hopefully kind of hone into some questions that I believe all of us received after our initial call, that kind of makes it a little bit more clear as far as, you know, what if you gift this? What if you gift that? How does that affect your exemption going forward if it does sunset? So let's say we've got an individual and he passes away in 2026. And let's say that the estate tax exemption sunsets and he decides that in 25, he does not want to make a gift at all. So, and the fair market value of his assets are 25 million. He made no gifts. So, and let's assume, you know, this is kind of just trying to simplify things so we kind of drive in this concept, but let's assume that there's no appreciation between 2025 and 2026. So value of assets after gift is 25 million. And then let's say that in 2026, that exemption reverts back to 7. Now it might be 7, it might be 7.5 if it does sunset, but we're gonna, for simplicity, we're gonna say it's 7 million. And that's a little bit less than the current 6,995,000. So upon his passing, he'll have assets subject to estate tax of 18 million, which is the 25 million less the 7 million exemption. So if you multiply that by 40%, you get 7.2 million. All right. Now we're going to go to scenario 2. And you're like, well, what if my client gifts 6 million? Is that really going to make a difference, assuming there's no change in asset values from date of gift to date of death? So in this case, we've got the same fair market value. We gifted 6 million. The value of his estate is 19 million, or his assets, I should say, is 19 million. So his exemption is only 1 million because he has 7, but he's already used that 6. And that goes back to this slide we had before, is that these gifts use this portion first. So if this goes away, you've already used the 6 million here. So now you've only got 1 million. And then he dies, he'll have 18 million subject to estate tax. So if you notice, there's really no difference between scenario 1 and scenario 2. They're going to owe the same estate tax. Now, some of you may be like, well, what if we don't want to give the full 14 million? We only want to give 11. So, well, I've got an example for that one as well. So this is an example of same facts, except the taxpayer decides to give 11 million. So the value of his assets at date of death are 14 million. And because he gifted 11, he has no exemption because that's more than the 7 million. And the asset subject to his estate tax is the 14 million times the tax rate, that's the 5.6 million. So if you notice, the difference in estate tax between scenario 1 and scenario 2 is 1.6 million. And there was so basically the IRS came back and had an anti-clawback provision saying, look, if you decide to gift more than the old exemption, we're not going to penalize you for it. You're going to get the benefit of that. And this is what this kind of represents. So in this case, they gifted more than the old exemption, but when they pass away, they're not making them pick up that additional 4 million in assets because he gifted those assets during that or gifted that during the Tax Cuts and Job Acts and before the sunset of the exemption. So in this case, you can see that there at first we had an estate tax of 7.2 million. In this case, we've got 5.6 million. And then to kind of further things and kind of goes back to the concept, if you have the ability to gift, it's important that you think about maximizing what you gift. And this kind of confirms the effect from an estate tax standpoint. But keep in mind, there are 1,000 factors to consider. And I think Rachel and Leonetta can agree that, we talked a little bit about basis and, when you pass away with an asset that you own, the new basis becomes the fair market value at death. However, if you gift an asset, it's carryover basis typically. So all those factors kind of play into an analysis of one, what assets to gift, because if you have a choice, if you have a choice, you'd probably want those really low basis assets to stay in your estate, and then you might want some higher basis assets to go in trust. And again, that depends on the type of trust. It also depends on the potential growth of the asset as well. So all those factors are considered when thinking about which type of asset or asset selection you want to gift in trust. But to our scenario 4, in this case, we've got same amount of assets, but this particular taxpayer decides, I want to gift the full exemption amount. So the value of his assets after this gift is 11,000,010. So much like in this example, the IRS says, okay, well, we've got this anti-clawback. We're not going to come and penalize you because you gifted more than the old exemption, even after sunset. So this is the value of your assets at date of death in which estate tax would be imposed. So in this case, you have a $4,404,000 estate tax. So if you kind of look at the beginning number, 7.2 rather than 4.404 million, you essentially have an estate tax savings of 2.796 million because you decided to maximize what you gift in trust. So
Thank you, Michael.
yeah, and we're kind of, this could be an example of different types of trust. It doesn't necessarily have to be a SLAT. We talked about that, and Leonetta is going to jump into some additional planning opportunities, different types of trust structures that I think will be good. We mentioned quite a few of those prior, but Leonetta is going to take a little bit deeper dive into some of those.
Okay. So Rachel, did you want to finish up with some of the advantages and disadvantages of the SLAT, or
Sure. And then I think what we'll do is highlight that, not every trust works for every individual or family. So going back to Michael's slides, and this clawback and, what that really means. The clawback, the IRS said they're not going to do this, but you really are giving up and using or losing this extra amount on the exemption. And so you have to gift above and beyond that old exemption amount in order to make the numbers work, to reduce that estate tax exposure, as Michael showed in his slides. And so for the SLAT, that concept is that if you're giving away above and beyond, and again, that can be a very scary idea for a lot of folks out there. And so having the assets be available to the spouse with the idea that, you know, that spouse is going to share, and the two spouses will benefit collectively because of that distribution to the spouse, that can provide some peace of mind and some relief for individuals who are really looking at how much they have to go above and beyond, or the amount of gift. And so, you know, the idea here is that that's the pro. The downside, you know, the SLAT terminates typically at the death of the beneficiary spouse. And at that time, anything left in the trust would pass to the remainder beneficiaries, who are typically going to be the couple's children, grandchildren, perhaps other family members. And so that is something to keep in mind. One of the big concerns with this type of a trust is divorce. You know, what happens in a divorce situation? Do you lose access to those assets? In general, yeah, unless you have provisions in the document that would specifically address this and provide for flexibility, maybe at that point to bypass the ex-spouse, and kids or perhaps a future spouse would be able to receive benefit from those. And so, you know, you really have to consider that type of scenario, or the health of the spouses, and consider family health history, so that you go into it with eyes wide open, understanding that these are considerations and the negatives to something like this. And so, you know, keep those things in mind. And the other thing to factor in is, you know, who's going to be the trustee? Is the spouse the trustee? Should the spouse be the trustee? And, you know, Leonetta, giving what you work on a daily basis, what are your thoughts as to having the spouse be beneficiary and trustee on something like that?
You know, depending on the situation, if the beneficiary spouse serves as the sole trustee, in the SLAT, the distributions must be limited to HEMS provisions, which are health, education, maintenance, support. So if you have a third-party trustee acting as the trustee, 9 times out of 10, they have a little bit more discretion and would be able to increase distributions from the trust outside of the HEMS provisions if that were necessary. And a you know, beneficiary spouse doesn't have that ability to make those adjustments as far as distributions go in the trust. So it would not be a bad idea if you decide that you want the beneficiary spouse to be the trustee, that there are provisions in the document that allow the beneficiary spouse the option of appointing an independent trustee or co-trustee, because that also deals with the issues of, you know, if the beneficiary spouse becomes ill, if there becomes a competency issue, they can, you know, the independent trustee can take over. And having 5x5 powers inside the document would allow the beneficiary spouse to withdraw like 5% of the principal annually. I mean, $5,000 or 5% of the trust assets. But that might not get you where you need to go if you're looking at large distributions that you're needing outside of the trust. So having an independent trustee is probably not a bad idea when you're thinking about a SLAT. because it gives you a lot more flexibility.
Yeah, I agree completely with that. And I see we have a question here, and really this is about the impending sunset and the federal estate tax exemption decreasing in 2026, potential for marital dissolution, and building in maximum flexibility. So I think with that, what we are looking at is having an independent fiduciary and not making the spouse the fiduciary and the beneficiary, both, so that there are checks and balances there. Having language drafted into that trust document that, for example, a bond clause. So if there would be a divorce, that that spouse, the current spouse or now ex-spouse, is not receiving those distributions or the benefit any longer. And there is capabilities to draft in provisions that would allow a subsequent spouse to step in and receive. So the donor would not just be out entirely. That might take some time, given the divorce and moving forward. And you could have remainder beneficiaries who are the kids, and if they are in line to receive that business or that asset, that can be great. But then I would say you need to have provisions drafted in to really protect what that asset is, and have somebody at the helm who knows what they're doing, so that these children can benefit or be part of that. I also would consider putting in something like swap powers, okay, on those assets, so that that asset could get pulled back out if it had to be pulled back out. And again, that opens up a whole other discussion about, what is a trustee looking for in situations like that? How do you swap? But I would really want to see language drafted in that tries to secure that as much as possible. But guess what? If we don't advise that if you are single, you run out and get married before the end of the year to take advantage of this type of a trust. And if you're not feeling good about your current situation and you are married, don't do one of these things and hang in there, right? And tell yourself you're doing it for the tax breaks, because boy, the tax tail shouldn't wag the marital dog, so to speak, in something of this nature. All right, so with that, as you can see, this just is not an end-all be-all strategy for everybody. And so are there other types of trusts or structures out there that can be put together, to maximize the exemption or increase tax efficiency? Yes, there are. And so Leonetta, why don't you walk our viewers through what some of those might be?
One of the ones that I thought about, and we sometimes don't kind of address them, and they were left by the wayside for a little while, but they were becoming more back in favor, is an irrevocable life insurance trust. So we can purchase a policy in an irrevocable life insurance trust on the grantor insured, and the policy is owned by the trust. There are contributions that are made to the trust on an annual basis to cover the insurance premium. And there's generally crummy powers that are drafted into those trusts that give the beneficiaries of the irrevocable life insurance trust a 30 to 60-day duration, and they can withdraw a portion of the gift to the trust. And those gifts to the trust qualify for annual gift exclusions for the donor. 9 times out of 10, one of the things that we're going to have a conversation with the beneficiaries about whether or not the attorney is having that conversation, or the grantor is having that conversation, or the trustee. We do not want the beneficiaries to exercise that power to withdraw the funds that were deposited to the account, because that's what we're using to pay the insurance premiums and allowing the grantor to get the annual gift tax exclusion. So you can put as much money, I mean, the value of those policies can be as large or as small as you want. The benefits are the principal death benefit at maturity is not generally taxed. The dividends and the interest that is earned from the time that the policy matures until those funds are paid out is 9 times out of 10 what the insurance company is going to provide us on the 712. And that's the taxable component to the beneficiaries.
Hey, Leonetta, can
Yeah.
I speak to something right
Sure.
quick? So just so everyone knows, so depending on the terms of the trust, you might have an annual exclusion for regular gift tax purposes, but not for GST tax purposes. So it's important to kind of differentiate between those two, because a lot of the times we might have, I want to say there could be a case where you've had a life insurance trust where you've been making annual exclusion gifts for, that there might not be a thought to file a gift tax return, but it doesn't qualify for that annual exclusion for GST tax purposes. So as just kind of a benefit, if you do have those situations where the GST tax could apply, you'd probably want some method of keeping up with that, and by filing the gift tax return and allocating an exemption because no annual exclusion applies for GST, that very well might be a very smart idea.
And that's where it's really important that you, the team that you have working with you of advisors can provide you with that information. And that's something that they're looking at on an ongoing basis. These life insurance trusts can be a really great tool for philanthropic clients. You could use the excess dividends that are generated from the policy, depending on the size, to pay those dividends out to the charities of your choice. I'll give you an example. I had a client that had a $15 million life insurance policy. The premiums did not eat up the entire dividend that was paid on the policy at the time he set it up. And he had 2 children. He decided that his children needed to be aware of their circumstances and what was going on in their community. So he used the excess dividends that were generated from the policy and had his 2 children do research about nonprofits in their community to determine who they thought would be a great recipient of some of these funds. So they did this every year, and every year he would give them a certain amount of money that was the excess dividend, and they decided what 2 charities in their community would get the excess dividends. So they were not only having the insurance policy that would mature at his death, but during his lifetime, they were able to distribute assets out to charities that made a difference. And one of the things that we wanted to make sure that everybody had in their toolbox is that if you have an ILEC that you've actually set up and you're no longer interested in continuing to hold that policy to maturity and to pay the premiums, please let us know. We are more than willing to help you figure out how to deal with the life settlements, which means that you could cash in that policy. And there also are viatical settlements that if you know of somebody who has a terminal illness, they can sell that life insurance policy at it's a little bit less than face value right now. And this allows the terminally ill individual to have access to those funds that were in the cash value of the life insurance policy. And then the individual the viatical company or individual who's purchased the life insurance policy will be the beneficiary at the death of the terminally ill previous owner of the policy.
That's a really good point, Leonetta, and I'm going to pop in here because I see we have another question. And so I'm going to read it here, team. And Leonetta, it's directed to you, but I think it's a team effort. So, but we'll see if you want to take it here. What are repercussions if the grantor fails to provide crummy notices to the beneficiary?
You may not have the exemption that you believed that you had, because 9 times out of 10, you aren't filing a tax return for your children or gift tax return because you're using the exemption that is under that gift tax filing requirement, except for in the situation that Michael provided. I'm trying to think. We've had the, if I've had a situation where the IRS has come back and pulled those funds back into the estate of the decedent when they pass away because they did not meet the qualifications. And, it's one of those things where we've had this conversation on numerous occasions because I've had a couple of attorneys draft a crummy letter that they did when the account was set up, and felt that took care of all of the crummy notices that would be required for the life of the trust, and discovered that was not the case. The asset was pulled back into the grantor's estate.
Can I speak to that, Leonetta?
Sure.
So that actually, you may face this more if you actually have a federal estate tax filing and you have a client who owes estate tax. So I had a situation where we filed an estate tax return, and actually that was one of the questions that the IRS came back and asked was provide the crummy withdrawal notices for these gifts to the trust. And what that crummy withdrawal does is it makes that gift a present interest. So in order for an annual exclusion to apply, the beneficiaries have to have a present interest in the gift. And if they have a right of withdrawal immediately, that creates that present interest, which then applies the annual exclusion. So if there's no crummy withdrawal notices, that's what the IRS is looking at, is saying, well, you didn't provide the notice, therefore they didn't have a present interest in that gift.
Right. And the term crummy notices, it's not because they're unpleasant to provide. They're actually very brief. It's a 1 to 2 page document. It's easy enough to put together, but this was the name of the family in a tax case that dealt with this exact issue. So that's where that terminology comes from. And you just have to ensure that the trustee is sending these things out and doing so timely. It's really not onerous to do this, but it does have to be done. To both Leonetta and Michael's points, it does have to be done to make sure you have documented that present interest, that completed gift.
I noticed that we have about 13 minutes left. So maybe we can touch a little bit on the state gift tax law by state.
I'm sure we will jump into that a little bit here. And so as we discussed a little bit last time, in addition to the federal government, states are free to tax their residents as well. And at this point in time in 2025, there are about 18 states that have some form of tax, whether a state tax or inheritance tax. Here in the upper Midwest, now effective January 1 of this year, Iowa dropped out. Iowa had inheritance tax, and they have now decided that is not something they're going to continue with. So Minnesota, we really kind of stand alone here because the Dakotas, Wisconsin, Iowa now are free from the tax situation on their residents. So we want everybody who's watching this, whether you're watching because you're advising clients or you are a client, that you are aware of what's happening in your state, in your home jurisdiction, because that can have a major impact. Even if you are not in a position where the certainly current federal estate tax is an issue for you, or the, proposed legislation does not, even if that passes, if you're not in a position where you are in fear of a federal estate tax, or even if it doesn't pass and we see the sunset and we see this big exemption amount get slashed in approximately half, that doesn't mean that you don't have something to consider in your home state. And so Minnesota, for example, each of us here, we have up to $3 million we can pass tax-free to anybody we want to when we pass away. Now, unlike at the federal level, we do not have portability here. Okay, so I say it's a use it or lose it proposition. And the trouble is that if you are even in a spousal situation, okay, you might say, well, I want to give my spouse everything I have. Okay, and together you have $4 million. You have two, your spouse has two. You gift your $2 million to your spouse. That's lovely. Okay, there's a spousal exemption. There is no tax on that spousal transfer. But now essentially what you've done is you've taken your $2 million, you've dumped it into your spouse's bucket. Okay, and when your spouse kicks their bucket, the state of Minnesota isn't going to ask, did you get this from your spouse? Okay, they just simply tally up what that second spouse had when he or she passed. And if there is an excess of $3 million, now there is an estate tax problem. So really it comes down to, after both spouses have passed away, that estate tax would be realized. And there are often ways, we talked about this last time, certain types of revocable trusts we can use to structure your estate so that we can control the disposition of assets in a way that makes the estate plan tax efficient. Even if you are still in a position, let's see you're in the gap, okay, between the Minnesota exemption amount and the federal exemption amount. Then some of these strategies that we talked about today might still apply for you. SLAT might apply, that might sound good. If you have a big life insurance policy, and life insurance is tough because you might be paying big premiums on a policy that during your lifetime, you're not benefiting. The way that asset is designed is that the money flows in after you've passed. Okay, now whole life might be different and there are, examples that we could get into maybe in another session, but largely that asset, that would be great to remove that asset and the value of that asset from an estate by structuring an ILET, putting that together. We touched a little bit on the concept of something like a charitable remainder trust, a CRT. And Leonetta, maybe you could speak to that a little bit here in terms of how that would look to give somebody, perhaps an income stream, and yet get some assets out of their estate.
Yes, definitely. There are, a couple different options from charitable trusts. And so we've got a charitable remainder trust, and basically what that is, there's, a fixed percentage of the assets that are placed into the trust are distributed annually to a class of beneficiaries, which 9 times out of 10 is family members. So, and then at the conclusion of the trust, either whether or not it's drafted into the document, some certain amount of years that you want that CRUT to exist, or at the death of the beneficiary or the group of beneficiaries, then the balance of the assets that are held in that trust are distributed to the charities. And the one nice thing about this is that these trusts, the CRUT and a CRAT, which is the kind of an annuity payment that goes out to a class of beneficiaries. So there's a valuation that's calculated with inside the document, and that annuity is established. It's paid out to designated beneficiaries, has 9 times out of 10 a stipulated term. And then at the end, that asset is distributed to the charities. So if it goes to the income to the class of beneficiaries for life or some certain period of years, and allows for flexibility in managing the assets that are held in the trust, there is a charitable deduction available for setting that up. The other option that you can use for funding these trusts are your life insurance policy or a life insurance policy. So, how is it then has to be determined how you're going to get the funds out, but it would have to be a life insurance policy that had an income stream that was coming out of it. But you can use the life insurance to contribute a life insurance policy to various charities as well. It gives the charities, you name the charity as the beneficiary, or you transfer the ownership of the policy to the charity. And or you, as I indicated before, you can donate the policy dividends to the charity. And there's also what we call as a charitable lead trust, which basically the charity is benefited during the trust terms, and at the expiration of the term of the trust, the remaining assets, whatever's left in the trust, get distributed to the non-charitable class of beneficiaries. So it could be family members. So there are 2 different types of charitable lead trusts that are available. One is a grantor charitable lead trust, And that means that the grantor retains the control of the assets of the trust and is responsible for the tax obligation of the assets and the income that is generated. They pick up whatever income is generated on their individual tax return. On a non-grantor charitable lead trust, it's irrevocable. And the grantor basically is giving up control and is no longer responsible for the tax liability.
Perfect. Okay, great. There's a couple questions here
Okay.
that I want to get to before top of the hour here. One is the amount of the annual gift equal to the annual life insurance premium, and this would be, of course, for the island.
Not
Not
necessarily.
necessarily. Yeah.
Okay, great. And I'm going to get to this one. This is an entire hour right here, at least.
Yeah.
What strategies do you recommend for handling assets held in IRAs and 401ks? Want to avoid beneficiaries being required to withdraw assets within 10 years of my death. Well, we just need to replace Congress then and get rid of the Secure Act is what needs to happen there. Because under the Secure Act, there is a 10-year window that beneficiaries are under to pull these assets out. Stretch IRA is really no longer available. Now there are certain beneficiaries, EDBs eligible, beneficiaries that would be able to receive assets and essentially stress that, pass this thing out over a much longer time. Spouse, it could be a disabled individual. But Michael, what are your thoughts on this from the tax component here?
Yeah, so I tend to agree the Secure Act issue, but there's kind of, this is more of a specific question. So Geraldine, if you'd like to reach out to me, I'm happy to discuss it with you. But essentially, depending on your intent with your assets, there could be some charitable planning there, depending on if you are charitably inclined. So that those are some options that you could look at. There's also, some of it may depend upon your kids and what their tax brackets are, and if it makes more sense to try to set up some kind of distribution out during your life, and that way potentially impose a lower tax rate than having a very large amount pulled out at your children's rate who may be higher than you. So those are some things that are really individual to you. That could be an aspect of planning, but outside, to Rachel's point, there are certain defined beneficiaries that have a different payout scheme than 10 years. But in the event the 10 years does take place, there's not too much you can get around that. And that's just kind of what the law is currently.
What I think on something like this is that this is where your CFP, your financial planner, comes in to play early because, to Michael's point, you could look at making some changes during your lifetime. You could look at doing some Roth conversions. You could look at timing some of the withdrawals with a charitable contribution annually, so you can try to offset some tax on that. Certainly, you'd want to be careful not to make withdrawals if you can help it before the point at which a penalty would, you want to do that in a smart way. In terms of spouses working together, one thing that I will see sometimes is that spouses will give some of the IRA to their surviving spouse and some to their children. And then the surviving spouse will reciprocate, because now you've got basically 20 years to pull out. You've got 10 years perhaps from dad, and you got another 10-year window on an IRA that you would have received from mom. And so sometimes you can play with those numbers and strategies a little bit, but those assets are tough. They're just tough given what the current law is. And have a meaningful conversation with, I would really recommend your financial advisor who can run some scenarios and look at time horizons on something like that. That's key.
Yeah,
You
I
know,
think that's
I know we're past the hour. I do want to give, there's one last question. Can you make later additional gifts to an existing SLAT after it has been funded initially?
Sure. Yep, you can do that. And then you just would have to keep in mind that even though the concept of this is you're giving assets to your spouse, you're really giving it to a trust. You've got to report that gift, and particularly if it is above the annual exclusion amount, which means that you need to timely file a gift tax return on that and disclose what the asset was that you made the gift of to the spousal trust, and have backup documentation to support the value of that gift.
Oh, great. Yeah, we're just a couple minutes past the hour. Again, great subject. I love your expertise and your ability to explain it where actually I can follow along and understand the majority of it. So again, Rachel, Leonetta, and Michael, thank you for your time. And based on some feedback, we'll look at trying to do another webinar on this subject of estate and trust planning. Thank you and have a good rest of the week.